Morning, everyone. Let's start out with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Good morning, everyone. I was just thinking that we have, now that Roger's here, we don't, but we had a majority of people here have law degrees. Pretty cool, huh? Okay. You'll notice our friend Andy is unable to be here today. And so I'm going to do a backwards introduction because Roger told me I can run this however I want. So Andy is not here. This is Nico Hash and there, Keegan Shea from the county attorney's office are here to kind of guide us through things. And Roger Balls, the CAO of Lewis and Clark County. Good morning, gentlemen.
Good morning.
To my immediate left is my co-conspirator, Tom Rolfe, Commissioner.
Good morning, Chair Payne.
Good morning. And Brandy Spangler, who kind of runs all the electronic stuff and keeps us functioning, and our friend Greg McNally. I knew I'd come up with your name. Good morning, Greg.
Good morning.
Head of the planning department. We have a sign-in sheet right at the front. There's a little table. Put your name and contact information on there if you would. Consent action item. Mr. Balls, you're up.
Thank you, Commissioner Chair and Commissioner Rolfe. You have one item. It's item 2A, Resolution 2025-22, declaring county property surplus property, and staff recommends approval of that item. Thank you, Commissioners.
You need a motion? No. Let's see. First, we have to. Questions. Is there any questions? We know what we're doing, or we know what, we trust the people who present this to us. Is there any public comment? Seeing no public comment, now we need a motion.
Chair Payne, I move to approve the consent action item 2A as explained by Mr. Balls.
Seconded. Is there any further comment from the commission?
None.
We have reviewed this. We know what it is. So let's vote on it. It's been moved and seconded that we approve the consent action item as presented by Roger Balls. All those in favor?
Aye.
Aye. Any opposed? Motion passes 2-0. Thank you. Number 3 on our agenda is, it's Ann McCauley and Jenny Chambers are presenting the grant application to Senator Sheehy's office for a congressionally directed spending request. Proceed, please.
Good morning, Chair Payne, Commissioner Rolfe, Ann McCauley, Director of the Grants and Purchasing Department, and as noted, Jenny Chambers, Director of Public Works, is also with me today on this item. Before you is a grant application for Senator Tim Sheehy's office. A congressionally directed spending request is the term that is used for these. About 2 weeks ago, 2.5 weeks ago, we received notification from Senator Sheehy's office that they were soliciting these congressionally directed spending requests through his office. This is something that other congressional delegation in Montana has not traditionally done on an annual basis in past years. So we were happy to see this come through Senator Sheehy's office. We also had applied for something very similar through Senator Daines' office in March of 2023, and Jenny can speak a little bit more about the status of that project. for that request. This request is to do a engineering and planning project for Country Club and Williams Street, which has been
What
designated.
was the street?
Wil-
Williams. Okay,
Williams
thank you.
Street. These roadways are the ones that feed into Fort Harrison Military Installation, which houses the Montana Army National Guard, the Fort Harrison Veteran Affairs Medical Center, as well as our main access points to Spring Meadow State Park, which I looked up recently is the third most visited state park in 2023 in the state, and a road that many county citizens use on a daily basis to commute to and from Helena for work, school, as well as commerce activities. This roadway also serves as a primary thoroughfare for the West Valley Fire Rescue and the area that it serves. The traffic count on Country Club Avenue is approximately 5,000 vehicles per day, and I believe that number is actually a little dated and goes back a few years. This request would be up to $575,000. The total project cost is $7,666,550, and the county is able to match up to 25% or $191,550. This approval could come as early as the new federal fiscal year, October 1 of 2025, but it just kind of depends on congressional and FY26 budget status that happens back in DC. And with that, I'll let Jenny kind of speak to the specifics of what the project will do.
Thank you, Ann.
Good morning, Chair Payne and Commissioner Rolfe. So Ann did a great summary of kind of the grant application for the Senator Sheehy's office. If the money was awarded, what we would do with the funding would be an engineering design effort to try to determine that whole study corridor based upon the evaluation of what's needed. So just in summary, I'll give you a little bit of information on that. Bear with me.
We have a fairly short agenda this morning, Jenny,
Do you?
so,
Okay.
there's no pressure here.
Good, thank you. Appreciate that.
It's all very important, but brief.
So Chair Payne, as I mentioned, it would be an engineering design of the designated route on Country Club Avenue and Williams Street. It would be an alternative analysis, a geotechnical review, and then a scope evaluation of what would need to be done in that area on future reconstruction of the road. Right now, the road is very narrow. There's a lack of shoulders. There's drainage issues with wetlands nearby. The deterioration of the road subsurface is failing. So we would evaluate all that as far as what would be needed for maybe widening the road, doing some pedestrian bike lanes, things like that for a crossing, and then also addressing the Y intersection on Williams and Country Club. The engineering design would then allow us to seek additional federal funds for full construction of that roadway. So yes, the design funding would be $750,000. And then later on, we'd have to take that information on what the construction costs would be to find federal dollars moving forward.
Jenny, just to refresh my memory on this, isn't it, this roadway is particularly problematic because it is a defense access route, therefore must be built to standards considerably different than our regular county roads. You have to be able to have the heavy weight of military apparatus on it. Could you go into a little more detail as to why this one needs specific attention?
Chair Payne, certainly. So this area in this roadway on Country Club Avenue is designated as a defense access route road. That means it's a critical, mission critical roadway for the military operations. There are heavy loads that need to operate and utilize this roadway, but right now, and has been for several years, it's a weight restricted road. So the military cannot use this designated defense access road because the road is deteriorating and failing. If you add additional weight on that, it would further damage it from the traveling public and the safety concerns for that roadway. So in the future, yes, we'd like to build it to highway standards, really improve the subsurface of the road to handle those heavier loads based upon this corridor, and then also provide the military the ability to use that road to stay off of Highway 12 and William Street, or where we have a pretty important bridge as well off of William Street that we'd also like to maintain that infrastructure moving forward. So Country Club, if it was developed, would be the main corridor for the military operations, built to highway standards that could handle those heavy loads, while we also address that wide intersection on safety concerns for the other traveling public that would help this effort long term. The other thing I'd like to mention is it's a main corridor for evacuation of the area for emergency services. So if there are something that happens in the area, it would be a primary location for evacuation. Right now, it's utilized somewhat by emergency services, but also fire trucks. Some of our heavier equipment also have weight restrictions for that roadway.
Okay, thank you, Jenny.
If I might,
Certainly.
Chair Payne, one of my concerns on it is the steep sides on that road. Is that going to be addressed as well?
Chair Payne, Commissioner Rolfe, certainly. When we look at the design elements, if we get this funding, it will take all those safety concerns and factors into place, making sure that if there are steep areas that need to be addressed, it would be guardrailed, the appropriate safety control measures in place based upon that design. And then what that's going to give us is going to give us a complete picture of what that roadway would need to look at for reconstruction, and then all of those safety improvements. Then we can then try to seek construction dollars to build it to those standards.
I might just comment. I drove that again just a couple days ago, and I was really concerned about those steep sides of that heavy equipment on a low boy or something. If they got just a little bit off, there'd be a terrible accident. And I think it's very important that we're doing this, and I appreciate staff going ahead and working with the congressional offices to try to get something done here.
Chair Payne, Commissioner Rolfe.
Yes.
I think Commissioner Rolfe brought up a good point. You know, you drive that road today. Some folks might not realize that the road is failing below that. As you guys recall, last summer we did the interim solution to do an asphalt overlay to help with the drivability of the current road surface, to get rid of the humps and the bumps and the additional potholes. That is just a temporary interim solution. So if we still need to move forward with what that reconstruction would look like. So right now we're in okay shape, but moving forward, we need to do that reconstruction, and it will fail based upon the interim option that we did this last summer.
And one more question.
Certainly.
Should we get the funding for this? Then would that essentially get it into a shovel-ready state, so that if we could get the funding for the work that needs to be done, we could just move right ahead with it?
Chair Payne, Commissioner Rolfe, that's exactly correct. It will have a 75 to 90% design of the project. We'll have geotechnical work evaluated. We'll have the environmental permitting details that we need in order to submit permits for when we do construction, how we need to mitigate the wetlands in that area. So we would have all that ready to go on the shelf, and we will know what that anticipated construction cost is going to be, so we can try to find construction dollars. And then the minute we secured construction dollars, we can then start moving forward with construction.
Great.
Yep.
Thank you.
Okay, now my turn. I visited with the manager of the country club a couple of days ago, and when we were talking about this very thing, and he said that our temporary fix did wonderful things coming from the west, but coming from the east to where it becomes a county road, that's city road, and it is a mess. Potholes, all kinds of things. Is there something that we can do to encourage the city to help us make this? And it seems to me the military, the heavy loads, they're coming in from the highway. They're going to have to be on the city section of that road too. And as I recall, there's a bridge there too. Is that weight restricted?
Chair Payne, I don't believe that that bridge is weight restricted at this moment. And yes, you bring up a good point. This project for what we're looking at doing for the design is from the county line to Williams Street. We will certainly partner and coordinate with the city of Helena based upon our designing efforts. Even for the temporary solution we did in 2024, we asked the city of Helena if they wanted us to partner on some way to go all the way to Jocelyn Street, which would include the city of Helena's portion. At that time, they said no, they didn't want to do that based upon maybe budget or other factors within their scheduling of work. So, but moving forward, now that we have formed the Greater Helena Area Metropolitan Planning Organization, Country Club is a urban route within that MPO designation. We will have discussions as the group with all of the Greater Helena Area MPO partners about this project and this effort moving forward. So it will aid in conversations and coordination and project plans. And if there's an opportunity to partner with the other, with the city of Helena on this effort, we will certainly do that. And if they wanted to maybe, as part of the design, include their portion in this design effort, maybe we could amend our contract with our consultant and add their piece to this puzzle moving forward. So what I will tell you is those conversations have occurred and will continue to occur. And with the facilitation of the Greater Helena Metropolitan Organization and all of our partners, MDT, City of East Helena, City of Helena, these transportation projects are talked about on a regular basis.
Okay, I like to know that this is not just, okay, we fix it to here, but then what the rest of it is, it's not our problem. We don't care what happens to it. We do care. The people who live within the city of Helena are also living within Lewis and Clark County. They are also our citizens. So thank you for your hard work on this project, Jenny. Okay. I already asked if there were any questions, right? Should I do that again?
Public comment.
Yeah, I'll do that. Okay. Is there any public comment on this matter? Speak now or forever hold your peace. All right. Commissioner Rolfe, I think we need a motion.
Chair Payne, I move to approve the grant application to Senator Sheehy's office for the congressionally directed spending request as explained by Jenny Chambers and Ann McCauley.
Second, it has been moved and seconded that we approve the grant application as presented by Jenny Chambers and Ann McCauley. Is there any further comment?
No, just that I think that this needs to be done, and I really appreciate staff moving forward and attempting to get this thing shovel ready.
Good. With that being the case, it's been moved and seconded that we approve this grant application. All in favor, say aye.
Aye.
All opposed, same sign. Motion passes 2-0. Was it something I said? Everybody's leaving. Sorry. Okay. Number 4 on our agenda today is a comment letter for court-ordered division for the Watson Family Trust. Our friend Christal Ness. That's a gorgeous sweater. I like that.
Good morning, Chair Payne. Thank you very much, Commissioner Rolfe. So this morning before you, you have the ability to comment on what is a court-ordered division. There was a complaint for partition that was filed with the district court. Recently, we've gotten a stipulation for the division and a proposed order. All 3 of those pleadings are attached to your packet. A court-ordered division pursuant to 76-3-2012 is exempt from subdivision review. It is also exempt from DEQ review. 76-3-2012 allows the governing body to send a comment to the court relative to the proposed court-ordered division on your concerns, recommendations, those sorts of things. I've also included in your packet as the last page, the proposed language for the court order division. And at this point in time, I'd like to show you where the property is and exactly what we're doing. I also have Andy Adamak here. He's representing the family on this proposed court order division, which is the result of the trust of the parents of the heirs. Chair Payne, we have lots of time, isn't that correct?
We are in no rush this morning. Well,
Okay,
I think maybe the people from the county attorney's office may have to rush off it. No, no, no. Okay. All right. Then we're in good shape.
so once again, I'm using the wonderful map that we have available on the county's website. We're going to take a little trip and go to Holter Lake. We're on the east side of the lake. All of these lots on the east side of the lake, save for some of the smaller ones, were actually created by the 20-acre exemption prior to 1993. The two parcels that we're addressing are this parcel and this parcel. We have Mountain Lion Gulch that comes in from the north. There's actually been some additional road improvements at the end of Mountain Lion Gulch, and we have Old Dock Road that approaches from the south. That also provides access to these two parcels. I'm gonna give us a little look at the aerial. And you can see here is one of the 20-acre parcels. Here's another one of the 20-acre parcels. You can see how Mountain Lion Gulch Road comes in from the west. And there are some additional road improvements, and I believe that Mr. Adamak is going to talk to you a little bit about that. We also have Old Dock Road that approaches from the south. There's also been some additional road improvements to that as well. Along with our court order division, we also have a proposed survey that I've included in your packet that shows that we've taken the two 20-acre lots and we've divided into 3 equal portions pursuant to the trust and pursuant to the complaint. And this is a copy of the draft survey that's been submitted to the court and is also included in your packet. At this point in time, because it is exempt from subdivision review, we have no ability to place conditions on this division like we would if it were a subdivision review. We have access on Old Dock Road and Mountain Lion Trail that are coming back to these parcels. You can see that we've now got a portion of the easement coming through here. These are possibly the new road improvements. I'll let Mr. Adamak speak to that. The survey will eventually be reviewed and approved by the Survey Review Committee relative to all of the components of a certificate of survey for an exempt survey. At this point in time, do you have any questions for me?
And could you, you put up the right map. This one works for me. So the configuration of the 3, or it's just the 2 lots to the north that we're talking about splitting?
These 2 lots, these are both 20-acre parcels, will now have 3 lots. We'll have a line here and a line here.
Okay.
So these 2 will effectively become 3 split from the north to the south.
Is there currently a house or a building or something on where the little green light shows?
Chair Payne, no, there isn't. I know that in searching our land use records, we did have an application for a septic system up here on one of these lots. That would require at least to have an address assigned to that lot so that our environmental health folks know exactly where they're going. So one of the things that I've put in the comment to the court is that all three of these lots should be addressed, and all three of the lots will have to comply with our on-site wastewater rules.
Thank you, Christal. That actually addresses one of my major questions is what are they going to do with the septic?
Right.
Tom?
Question if I might. What is our procedure as we go through this? Could you kind of outline that?
Commissioner Payne, or Chair Payne, Commissioner Rolfe. Yes, so what we'll do is we have a proposed draft letter. That's the last page in your packet. That is the comment that we will then put on letterhead. Chair Payne will sign it and we will send it to the court as our comments relative to this court order division. And essentially it is addresses. They're not required to get approach permits because neither Old Dock Road nor Mountain Lion Gulch are county roads, so they won't have to get approach permits to access onto those roads. Most of the development up in this part of the lake, save from Beartooth Road, we always require an approach permit if you're accessing onto Beartooth Road. But these smaller roads that are up here, we don't require approach permits for access onto those roads.
If I might follow up, so then we actually don't, all we can do at this juncture is just say, these are the things we'd like to see happen.
These,
And then the court either says yes or no and proceeds. Is that right?
Chair Payne, Commissioner Rolfe, that's exactly right.
Okay. All right. Thank you.
Just a little follow-up to that. So when Judge Manahan writes his, and I suppose I should have looked at the proposed order to make sure those things are included in his order.
Chair Payne, they wouldn't have been included in the order because the proposed order was submitted to the court prior to us having this meeting here today. So Judge Menahan may have the option to amend that order to include those few things that we've requested to be noticed to the petitioners that are going to be owning this property.
All right.
Judge Menahan may have the authority or the,
Chair Payne, of course he does.
okay, and this is through, I mean, this is part of his job. Okay.
Chair Payne, yes.
But he doesn't have to.
And I believe that Mr. Adamak is here to possibly answer that question for you.
I'm very glad about that. Anything else, Tom?
No, I'd be interested to hear
Okay.
Mr. Adams.
How about if we see if Mr. Adamek would like to come up and address this august body?
Good morning, Chairwoman Payne and Commissioner Wolf and staff. Yes, Judge Menahan has authority to require additional language in the final order, taking into consideration the comments that the county commission provides to the court. And he sought your comment under a statute that required him to do that as part of a court-ordered partition of land. That statute isn't found within the actual partition statutes, but it's found in another part of the statute. So no question about authority. Clearly, he does have that. And the plaintiffs, and I should state and clarify that I do represent the plaintiff, which is the trust through its trustee. I do not represent all of the named parties in the complaint, meaning the defendants. One of the trustees is a sibling. They're all beneficiaries of the trust. They're all children of the Watsons. but I represent the trust. I'm not speaking for all of the parties, but I can tell you, I got all of the parties to agree to this stipulation. Okay, so I will tell you that that was a positive thing. And just to put a human face on this, these are second generation owners of this land. They are retirement or post-retirement age. They are trying to finish and close out this trust and distribute these assets in a manner consistent with how their parents asked them to do that. And the language of the trust indicated they would each get a 1/3 equal share. The reason we had to seek a partition is it's kind of hard to get a 1/3 equal share of 2 lots. So what they agreed to do through this stipulation and through this partition action was divide them into 3. So that's the backstory. But to address the primary concerns that I, as the attorney for the trust, thought that the county might have when you all looked at this, when we had this discussion, was access. And what I want to assure you is that access already does exist along Old Dock Road. With the original plat, there is a 60-foot wide access and utility easement that runs up Old Dock Road, the backside of Track 20, and then runs approximately to this location between the existing lots. That access is 60 feet wide. Prior to the partition action filing, Gerard Watson, one of the defendants, agreed to widen that 60-foot access at this location and at this location to facilitate access to these lots, to improve that access. The Sterling Ranch running here, you can't tell. There's significant slopage here, but you can see a roadbed has already been excavated within the confines of that existing easement. That easement continues and exists and was present before this partition action and will not be in any way extinguished and has actually been improved for access. The same, I would say, goes for the access point here. Mountain Lion Gulch Road coming up and then entering here. What's hard to see on this satellite image, but what I can tell you because I saw it with my own eyes last summer, is from this point forward, this Lion Gulch easement ends, but an easement was created with the owners north of this property, again, prior to this partition action, to open a circumference turn to allow access to a road that has since been improved that I'm showing you the pathway of approximately, that comes through here and feeds out into what would be one of the new tracks. This road that is portrayed in the certificate of survey that's attached to the stipulation would improve access to the newly created lot here as well. This easement that was created or would be created when the certificate of survey is filed is a 40-foot wide easement. It's not a county standard road access point. It's not to county road standards, nor is it required to be, nor are these roads that already exist. But the easement is improved with what the parties are proposing here to the internal lots. And so in terms of public health and welfare, I think that the stipulation addresses that adequately for access. And then, of course, these folks understand, and the comments would make crystal clear to the court, that any septic systems have to be permitted, any wells have to be properly applied for and permitted. And if these folks want to build structures and have these separate parcels exist, they should be addressed so people know where to go to respond when somebody calls them and says we need help. So from the plaintiff's perspective, the trust that I represent, we're going to encourage the court to incorporate the comments from the county. because they are what is required as a matter of law already. And just one other thing to understand is that the current covenants for this property only allow single-family dwelling structures. There's no commercial or business activity that can be engaged here. We're talking about single-family structures that would be built by these folks for their families' enjoyment. There's not going to be a large density. There's not going to be apartments, condos. There's not going to, be a commercial venture that would attract a bunch of people up these roads and create that kind of problem. It's just not allowed by the current covenants. So with that, the only other thing I wanted to do was I wanted to thank your assistant county attorney. Are you officially assistant county attorney? Nico, very quickly jumped on this last week when Judge Minahan brought it to our attention that he wanted to get your comment. And Christal very quickly came up with a staff report in less than 7 working days to get this in front of you on this agenda. And I asked them to expedite it because emotions are raw and parties are wanting to get this accomplished, and they've come to an agreement that we want to keep in place for this judge to sign this order. So thank you for everybody in this process moving as quickly as it has. Any questions?
Mr. Adamak, I have you mentioned that there are existing covenants.
Correct.
Can you tell me what a homeowners association what covenants are these that you're referencing?
Yeah, I do not believe that there is a homeowners association, but the protective covenants were filed by the original developer. And they were filed in 1996 or 93. I can't read that. Just for the record, it's at document 459473. That was filed in 1993. And what it says, what those covenants say, specific to your concerns, that all tracts will be used for single-family residence only, that no business, commercial, industrial use or business will be allowed. With respect to the easements that I outlined for you that already exist with the existing certificate of survey, they indicate that those roads shall be used and shall be 60 feet wide and are to be used and accessed by any owners of the property and include utility easements within those easements. And then to septic, in the county's concern, at section 3 of those easements, it states that pardon me?
Section 3 of those covenants, you mean?
Of those covenants, correct. I'm looking at the actual covenant document. Sure. Says that it addresses disposal of human waste by septic tank or cesspool or other disposal system which must meet the requirements of health departments of the state of Montana and of Lewis and Clark County, and shall be maintained in accordance with applicable rules and regulations of the state of Montana, of Lewis and Clark County. So beyond just the permitting, there are existing covenants that require them to follow the rules regarding septic.
Yep. You mentioned that one of the covenants has to do with a 60-foot wide road requirement.
Correct.
And I believe you told us that there's a 40-foot wide easement across the north end of the first parcel there.
Yeah, let's go to that certificate of survey if we could. And so to be clear, Sherwin, these covenants were applicable to the original certificate of survey that was filed and are applicable to the road system that was laid forth in that original certificate of survey. The road that I'm speaking of is an internal road, which is not part of the original platted roads. It's a newly created road. So from just a legal standpoint, we're not changing, this proposal doesn't change the existing 60-foot wide easements that are required under the current certificate of survey, right? Those already exist over here and over here. What we are doing, and as well as this portion of the internal road that affects this current tract and property owner to the north, that as well as a 60-foot wide. We only go to 40-foot wide inside the property itself with a new road. This is basically a driveway. Okay? It allows
That's basically a
access.
what?
It's basically a driveway. Consider it a driveway. It's servicing these particular lots. It's not servicing access to all of the other lots within the subdivision, and I don't believe is a violation of a covenant. The width of this internal easement and road that would be improved is 40 feet wide, as you had inquired about, and the physical constraints of the slope, the timber, and the geography kind of mandated that width, and that was a real push to get it that wide. Certainly wide enough for vehicles coming and going on the same road at the same time. So to answer your question, what we're proposing does not violate the covenants in terms of the width of that internal road.
I have a certain amount of experience with this sort of thing, and I'm always worried about, well, somebody wants to build a house on tract 1819, and they're going to go to the bank, and the bank's going to say, well, I don't think that's wide enough. I mean, does this address the issues of the owners of this 30 years from now? Is that a concern?
Well, we don't know who those owners would be, right? But at least the current owners and their concerns have been addressed in terms of how they could agree to arrange for access internally on their property and how they could practically install a road of this width. To answer your question, typically lenders want to look at this and say, is there legal access to the property? There clearly is legal access to this property from the existing covenants that already exist. All we're doing is improving internal access to these new tracks within it. And I think that's probably the only answer I could give you about how somebody might view this in 30 years.
Thank you for addressing my concerns.
You bet.
Tom, do you have any other questions?
Question, if I'm looking at this map properly, tract 18A would only be accessed from the north. Tract 19A would only be accessed from the road coming in from the south, but the tract in the middle, a tract listed as 1819, could be accessed from either one. Is that correct?
That is correct. And this easement that already exists, that is the 60-foot wide easement, currently provides access to both existing tracks, which is this center line that you see, okay? What we anticipate is 19A and 18 and 19 would utilize the existing easement already from Old Dock Road, that's 60 feet wide, that's also been widened at the turning radiuses of these corners. And that tract 18A would primarily use access from Mountain Lion. And technically, they're already accessed their lot here. The reality is they're probably going to build, develop, and permit a well and septic system down here, which is why this road needed to provide them this access from here. So they won't, to answer your question, Commissioner, they won't all be necessarily using the same access point all the time. Yeah.
Okay. All right. Thank you.
Yeah. Thank you.
Thank you. It's time for public. Wait a minute. Do you have something else to say? Just in case you didn't know, Christal is the authority as far as I'm concerned. Other comments? Christal, did you have a comment? Okay, is there any public comment? Speak now or forever hold your peace. This is it. Seeing no public comment, I think we need a motion.
Chair Payne, I move to approve the comment letter for a court-ordered division for the Watson Family Trust as explained by Christal Ness.
Second. It has been moved and seconded And now we have an option for further comment from the commission. Anything, Tom?
Seems pretty clear at
I
this
think
point.
we've addressed all of our issues. That being the case, let's have a vote. All in favor of approving the comment letter for the court order division signify by saying aye.
Aye.
Any opposed? Same sign. Motion passes 2-0. Christal, do you need anything else? Oh, good. My coffee's getting cold. At this point of our agenda, we will ask for public comment on any public matter within the jurisdiction of the commission that is not on the agenda above. Any public comment? Seeing none, this meeting is adjourned.